Good afternoon. I'm Erica Berg. I'm the current chair of the Georgia Bar's Dispute Resolution Section. I'm very excited today to be engaging with Brian Sutliff on the transition from advocates to neutral. We've had a number of requests, and I get a number of emails from folks trying to make that transition and ran across a fourth party and some of the things that they're doing, even in a technology space, and thought Brian would be a great asset to y'all to look at making that transition. So let me introduce Brian. Brian's an attorney with over a decade of experience litigating personal injury, medical malpractice, business disputes, and contract disputes in state and federal court. In his trial practice, Brian is the founding partner of the Sutliff Law Firm and has represented plaintiffs in cases involving premises liability, product liability, medical malpractice, mobile wrecks, truck wrecks, breach of contract, and business disputes. He also has represented defendants in contract and business disputes. Brian became a mediator when he realized that his true strengths and passions involved being a peacemaker and a bridge builder. He utilizes his vast life and professional experiences in the mediation to create deep connections that come from a place of trust and respect, which allows him to successfully negotiate and resolve even the most contentious matters. Before becoming a lawyer, I find this interesting. Brian was actually a high school English teacher. He was here in the Atlanta area, and he was also a football, basketball, and soccer coach. So if you know how to resolve conflict on that team of high school students, kudos to you. Brian attended the University of Georgia and the University of Dayton School of Law. He serves as the board member of the Lady Josephine Foundation, a nonprofit supporting families and research related to critical pediatric cardiovascular disease, pulmonary vein stenosis. In his free time, Brian enjoys spending time with his wife and their miniature schnauzer, Abby, hanging out with his 8 nieces. That's a lot of nieces. Playing golf, skiing, traveling, attending concerts all over the country, and building software solutions for himself and others. I think we're going to learn a lot from Brian today. I'm going to go off camera, but if you have any questions, I will be monitoring the Q&A in the chat, and I can field those questions to Brian as he presents. So feel free to let us know if you have a question. Thank you. And Brian, it's all yours.
Thank you, Erica. I really appreciate that. It was very kind of you to introduce me that way. And we're actually changing. We've got niece number 9 is coming very soon here. So again, thank you very much for having me today. I appreciate all the attendees that are here. And to echo what Erica just mentioned, I'm one of those people. I love to just have questions that are thrown out there as they occur, as we're talking about a subject matter. So if you do have anything, please don't feel free to throw it out there so that we can answer it as we're talking about a particular subject. Let me share my screen here. All right. So what we're talking about here today is managing that transition from advocate to neutral. As Erica mentioned, I have my own law practice. Previously, I was a high school teacher. I have begun working with Fourth Party, which is an online cloud-based practice management for mediators, where you can handle all of your scheduling and communication, document generation, invoicing, billing, all that kind of stuff, all in one place. In addition to that, I also mediate over at Miles Mediation now. And currently, I have a mediation going, and we're taking a break right now, but I'm just really excited to be here to talk to everybody. What we're going to hit on today are these 5 big topics: the attorney and their role as an advocate, as opposed to the neutral as a facilitator, the challenges and opportunities that exist in the mediation space today, and talk about some of the unique issues that involve dealing with pro se parties versus represented parties. And then finally, what a lot of people ask me about is the business of mediation, how to actually get it started, how to grow it, all of those kind of things. So this is our little table of contents, and we will just jump right in. The hardest part for me personally, and for most mediators that I talk to, making that transition from the attorney advocate to the neutral, is being able to step out of the role that you went to school for, you trained for, you litigated in court, you did all of these things to become a true champion for your clients. Well, as a mediator, you don't have a client to advocate for. Your clients are parties on the plaintiff side, the defense side. Just your advocating is going to be related more to an outcome rather than a party, and that's a difficult thing to overcome because I think that most of us in the practice of law make our position as an advocate part of who we are. I defend people when this happens. I protect companies from unjust lawsuits. I do these things. I am the soldier on the battlefield. And it becomes part of who we are. And it can, in many cases, color how we see the world. And making that transition, it can be challenging. It can be difficult. But ultimately, I'm here to tell you this. If you were able to get through law school, you passed the bar, or you just went through, you're not a lawyer, but you went through the mediator training, you are going to have the intellect and abilities to make this change. I promise you that. Might not be a smooth transition internally, but you can do it. And for the attorney side, they're that champion. They're that soldier out on the battlefield fighting for their clients. Their preparation in any matter is focusing on how do I win for my clients. Sometimes that's just how do I get the best deal? Sometimes that means how do I destroy the other side? And that is a very unique space to be in that does not jive well with being a mediator. Because as a mediator, we're the collaborator, we're the facilitator. Our preparation as a mediator, it's focusing on how do we get the best outcome for all the parties that are here. To do that, we've got to understand all the parties that are involved. I'll sprinkle in some stories here, but if people have questions, you can throw them out as well. Every single party has needs when they walk into a mediation. And one of the main jobs of the mediator, as opposed to the advocate, if I'm representing a plaintiff in a personal injury suit, I really don't care what the insurance company needs or what the defendant needs. I'm only concerned about my client. As the mediator, I'm here to facilitate these conversations. I have to learn what's the need that plaintiff has. Is it money? Is it an apology? Is it a set aside for medical treatment in the future? There's any number of needs that they have. I also have to understand in the defense room, usually represented by insurance in this example, they have needs as well, which is don't pay more than the case is worth. They've got to be, they have needs to understand the risk factors moving forward in trial, towards trial. So everybody's going to have different needs. We as mediators need to poke and probe and ask questions to try and understand where are those needs, and then work collaboratively to try and reach a resolution that meets not all of everyone's needs, because that never really happens, but to meet most of them so that everybody can walk away feeling like they were successful to some degree. And that's the really important part is winning here for a mediator means coming to a resolution where the parties agree to end their dispute and they get to move on with life. And it is a truly unique mindset to be in, because we've all been educated and trained to focus on one thing and one thing only. And you might walk into a mediation. I had one the other day. There was 9 plaintiffs and 4 defendants, and all 13 of those parties had different needs, and they had different goals. They had different expectations. And I can't focus on what any one of those are individually, but trying to pull them all together, put the pieces of the puzzle together to come to a resolution that falls somewhere in the middle of where everybody's thinking it should be. I've kind of hit on this, that the transition from the advocate to the neutral, the hardest part is overcoming that adversarial instinct, right? One of the really difficult things when you're in a mediation is what I call litigating while mediating. Okay, and it can be a challenge, especially when you start as a mediator, staying out of that mindset. The lawyers, they'll get into it. They want to keep litigating and talking about, debating issues, and some of that can be important, but it's not a fight necessarily in the mediation. It's trying to convince the other side that your view of the facts, your view of the circumstances is the correct one, and give them reasons why they should do what you're asking them to do. Common pitfalls that I fell prey to, and I know a lot of mediators making that transition from the advocate to the neutral, is the aggressive negotiation. For all the lawyers on here, whether you're a plaintiff and you've done the, I'm going to demand $1 million on a case that's worth 50,000, and I'm not going to give an inch. On the defense side, saying I'm going to, motion to dismiss. All these things, super aggressive tactics. They don't translate over into the neutral's position, because if you are aggressive in that sense, you're going to alienate one or more parties in the mediation process. And that just is a surefire way to end the day with an impasse, and usually with no real meaningful progress made on the case. So trying to pull back out of that mindset of being aggressive, you don't have to win anything. You just have to talk to these sides, get them to tailor, narrow their arguments down to what are the true issues here, and then get them to buy in to a deal that gets everyone moving along with life in a better position than they came into the mediation that day. You can't be a zealous advocate either. And that kind of goes with the aggressive negotiation. But I will tell you this, as a practitioner, there are some mediators that I just couldn't work with because it was just too clear that they were an advocate for one side or the other. And what I needed as a practitioner was a true neutral, somebody that can come in and tell me where I'm wrong, but also can go into the other room and tell them where they're wrong. Leaving that outside, one of the best ways a mentor of mine explained it to me was you could be in the cloud or above the clouds. When you're in the cloud, you can't see anything. You're just wrapped up in it. Or you can take your plane up 5,000, 10,000 more feet and you can see everything around you. And if you're able to remove yourself from the cloud, be able to see things as they are. Every party has needs. Every party has different motivations in this mediation. That puts you in that true neutral mindset. The ways that we get around it, the ways that I've tried, the ways that I've been taught by some very, very experienced, very successful mediators, instead of that adversarial position. I'll give you an example. In a personal injury mediation that I conducted a few weeks ago, it was their second mediation. And in their first mediation, the mediator came in to the plaintiff's room and said, I don't believe that you were hurt as badly as you say. Unsurprisingly, that mediation was unsuccessful because immediately that plaintiff was in a defensive posture, like, hey, this person that's supposed to be like the neutral that's trying to help the parties, he just told me I'm a liar. That doesn't seem very neutral. Instead of that, as a contrast, what I did and what most mediators do, you come in, it's showing that empathy, understanding that, hey, you're here and you don't want to be here. Something bad has happened, whether it's a personal injury dispute, whether it's a divorce, whether it's a contractual dispute, something bad has happened and people don't want to be there. And showing that empathy, trying to understand where they're coming from an emotional standpoint so that you can get that stuff sort of pushed to the side and focus on the task at hand, which ultimately all of these mediations are, in my opinion, they're just business decisions. And business doesn't really have any emotions. But to get most parties to that point, you've got to show that empathy. You've got to show them that you, as the neutral, you're also a human being that understands that they're going through a tough time, or they're a corporation that's having to make a tough decision, and that's not easy. So making that connection through empathy goes a long way, not only in helping you stay in that true neutral mindset, but also to help develop a sense of trust, a relationship with the parties, so that they can rely on you, that what you are doing is truly in the best interest of the deal, not of any one party. The other ways that you can do that is help with through facilitation, getting the parties to play out scenarios, asking them the questions that make them think, right? You're going to get a couple things out of it. You're going to get a lot more information than they were probably wanting to share with you. You're going to force the parties to get less out of a zealous advocate position into more of a reasonable, rational mindset when you are trying to facilitate more conversations, more of a thoughtful process for how do these issues play out in the future? What does this really mean? And that kind of goes along with the third point here on reflective listening. I could tell you this is probably the most important skill that I would tell any advocate transitioning to a neutral. Being able to make connections with people through reflective listening. We all share a couple things in common as human beings. One of them, in my experience, is that we all want to be heard. And whether it's the fact that we've all been to a doctor's office and they spent 3 minutes in there and we didn't really get to talk about it, and we go home and we're still suffering from something, we're going, the doctor didn't even listen to me. I hate that doctor. I'm not going back to him. All the way into a courtroom. From my days as a high school teacher, I had students that would complain about other teachers, like, they just don't listen to me. I'm not understanding this, and they're not listening. They just tell me I need to do something. Listening to the parties in a mediation is perhaps the most valuable skill that there is. It allows you to generate and develop true, mutually respectful relationships. And it's very simple. You hear these parties out, and the easiest way to do it is literally to just reflect back to them. Miss Smith, I hear you telling me that this has been a very difficult time for you during this divorce. And I hear that you're telling me, everything else, repeat it right back to her. She's going to get a sense of that she is being heard, a sense that her attendance at the mediation that day actually means something. I tell all the participants in a mediation in my opening statement, say, I don't want you to ever feel like this is just a process that's happening to you. I want you to feel like that this is a process that you are a part of. And the easiest way to do that is to listen to them. And then talk to them in a way that makes them understand undeniably that you have been listening to them, and that their opinions, their thoughts, all of that are being taken into consideration. And that goes a very long way, especially when you get to the end of a mediation and they're just looking for guidance. Parties do this all the time. If you develop that relationship of being an empathetic, listener, they're going to have more trust in your opinions on how to move forward. And that just sets all of these mediations up for a much higher chance at being successful in resolving the dispute. Now, developing new skills and competencies. I've found this to be one of the more interesting aspects of making the transition from lawyer advocate to mediator neutral. We really are just constantly learning things. I found that in my private practice, it was the different names, different days, different facts, but generally the issues that I was dealing with were kind of the same thing over and over again, which is fine, but you don't have to learn a whole lot all of the time. There's always going to be changes to the law. There's going to be new research that comes out on this, that, or the other. But I will tell you that when you become a mediator, it is a whole different ballgame, because now you're not just taking the same kind of cases. I've mediated cases that I could have never imagined handling as a practitioner. And not only that, you're going to interact with personalities that you've never encountered before. You're going to run into parties that have needs that you've never considered would be a need that a human being has. You will be constantly learning. You're going to be learning about more techniques and tactics to stay neutral and impartial. It has encouraged me becoming a mediator, and I encourage any of you that are looking to make the transition to start looking elsewhere for this. What I put in here is brainstorm beneficial solutions. Some of the best resolutions I've had in mediation, talking to a lot of experienced mediators, are not obvious. They are not obvious at all. They required a level of creativity that you wouldn't expect for the particular type of matter that was being mediated. But what that is really a testament to is good mediators, the people that truly make that change to the neutral mindset. They're looking all over the world, different businesses, different industries, research, all those things, to try and pull ideas from here and there and there. You might not need it today, but I promise you, if you do make this transition from advocate to neutral, you're going to have to come up with some creative solutions. And that, just by its very nature, requires you to be looking out, not just in your specific field of practice or your specific niche, but everywhere else, because the parties that come in, they come from all over the place. They're not going to share that same kind of niche thinking that many of us as practitioners and advocates have made our careers doing. Part of that ever learning process is when you're in the mediations, open-ended questions are your best friend. Okay, like I mentioned before, I've got a mediation going on right now. We're taking our break here while I get to spend some time with you lovely folks. One of the last questions that I asked him was, how are these injuries still affecting you? And I have not gotten the answer. I'll be curious when I go back in, but just to see the plaintiff's face as he sat back and opened his eyes in kind of a little bit of wonder. I don't know that it's a question that he has been asked. I don't know that it's a question that he's pondered, but I do know that when we reconvene that mediation this afternoon, I'm going to learn a lot. I'm going to learn a lot about the case, but more importantly, I'm going to learn a lot about this plaintiff and what their motivations are, what their needs are, and that will help me, talking in the other rooms, to come to an agreement that helps meet those needs. And open-ended questions, they're easy, right? They're very simple. You can just sit back and throw out the why. Well, how did that happen? You will have the front row seat to the lesson that I don't know where exactly I've heard, but there's a universal truth. People love talking, especially about themselves. Even the introverted ones. If it's about them, they want to keep talking. And people, when given the opportunity, will share a lot of information with you. And those open-ended questions become your best friend. Because for us as a neutral, as a mediator, the facts are important in the context of what we're doing, but the most valuable information is learning about the parties themselves, those needs, those motivations that they have, because emotion will trump intellect all day, every day in the mediation setting. If you can't understand what a party's emotional needs are, you're not going to be able to convince them with facts that they should or should not do something. You do have to learn those, and you have to tailor how you speak to them, the questions that you ask them, the deals that you present to them, and how you present those deals to those parties. You got to tailor that. And it's different for every single party, especially different in every plaintiff's room versus a defense room. And open-ended questions are a quick and easy way to get that process really going. I mean, I love, I mediated a case yesterday, and it was very difficult. I didn't know that we were going to get there. And then I just asked a simple question that I do in a lot of mediations. I said, Mr. Plaintiff, what's important to you? Just in life, in general, what's important to you? And that plaintiff talked for about 10 minutes, and I learned 5 different things about that plaintiff that I was able to use in the next few trips back and forth, and we got the deal done. A deal that I would have put a 5% chance on settling at the beginning of the mediation. We were able to close it out. And it's all thanks to just giving an opportunity for the parties to talk, giving an opportunity for them to share who they are and what those motivations, the important things in their life. And then you, as kind of we mentioned in the previous slide, you as the neutral, you get to play, the emotional personal detective of taking that information, figuring out, okay, well, how do I tailor presentations, more questions, deals, so that it speaks directly to this party? And then figuring out, how do I do it in this other room? And they have totally different needs. So the emotional management part is very, very important. I will admit that as a practitioner, there were plenty of mediations that I messed up right off the bat, because I came in like I was, we were in a heavyweight fight. I was not backing down, and that anything that they said that was in disagreement with my position, they were totally wrong. We weren't going to hear them out. Ready to walk at a moment's notice. Not the best way to start out a mediation. Like I mentioned earlier, there was another case where, one party calls the other party a liar. All right, we're in a difficult position. There's already tension. Anybody that's in mediation is there because there is tension. There is a problem.
So Brian, we have a question from Joseph Williams. He says, how do you manage the differing perspectives and the different needs of their parties and their attorneys? Do you have some tips on how to bring them together?
That's a great question. I think that's Joseph Wilson that I played some basketball with over the years. And if so, hope you're doing well, Joe. The bringing all of those together, understanding them, it is, I was going to pull up his question here, but well, that's all right. We'll just keep this up here. I handle it personally. I use a little thing here. This is called the Remarkable. It's like my best friend. I'm a pen and paper guy.
Oh my gosh, we can talk. We'll do a whole session on the Remarkable later. I just did it for the AAA panelists. It's a beautiful thing. So we can do an ad for
It's fantastic. To get to Mr. Wilson's question, it's a difficult thing if you're not organized, okay? Especially the more parties that you get out there. The ways that I help manage the emotional states is I do a couple things. I always start off my mediations and I tell the parties, these first few meetings are going to be long. I want to dig in. I want to get a true understanding of where you are, not just with the case, but where you're at emotionally, mentally, spiritually, whatever the case may be. There are some dynamics that are present in mediations, on this mediation, but won't be in the other. But I really want to get a grasp of where those people are. And I want to use that in the other rooms. Now, I won't, if a plaintiff tells me, hey, I'm struggling. I just need money. I want this thing to be over with. I'm not going to go share that in the other room, and I shouldn't. I have an ethical obligation not to share that. But I am going to go in there and say, hey, listen, the plaintiff is a reasonable person. The plaintiff recognizes that continuing to fight in this case isn't in the best interest of anyone. So they're here in good faith. They're really trying to get this done, and it will go a long way in the plaintiff's room if you give me a good offer here. Let's make a bigger jump than you were planning on doing, just to show them that they are being heard and listened to, that they are respected because you're putting more money on the case. So I will use all of those things to bounce around the rooms and kind of allow me to phrase questions, allow me to paint a picture that encourages the other side to respect what I'm learning in their counterparts' rooms. I will say this: I am not a huge fan of opening statements unless I have talked to the participants before the mediation starts. There is, like I've mentioned a couple of times, there's a surefire way to set a mediation up for failure, and that's to have a contentious opening statement. So in that regard, the way that I control that is I will talk to the parties before the mediations. If one of them or both of them is just like, hey, we're here to fight it out, I'll say, hey, you know what? We're not doing an opening statement. And if you don't like it, use a different mediator, but we're not going to do an opening statement. And the reason is I don't want anyone to feel alienated right off the bat. Okay, you're both fighting at it. So what does it matter if we fight in person? Let's fight through messages going back and forth that I can help control the tone. I can help make suggestions that doesn't alienate the other side as much. I think there was one or two other points in that, but I've kind of run off on my own tangent. So, Erica, if there was something else that was in there that you want me to hit on, please let me know.
No, I think, talking about opening statements is obviously one of the big things these days we all talk about.
I find that I find that to be really important on the emotional management side. All the parties that are there, they know all the facts about the case. You're not going to win people over in an opening statement. Everyone has come in with their positions fairly solid. So I'm not a huge fan of them unless people are going to be respectful. I mean, I love getting everybody together to say, hey, we're here in good faith. So sorry this happened, whatever the case may be, let's get the process started. But that is for in my process, managing the emotions, managing the tone of the mediation begins before the mediation starts. It begins with communicating with the parties, reaching out to them, trying to get information about the case, documents, and then having phone calls with them, just reaching out and saying, hey, just tell me about the case. How are you feeling about it? What are your expectations for this? What do you think the other side's position, their main points of contention will be? Getting them to talk about it. You will learn so much. For the most part, people want to come in there in good faith and try and really be collaborative and work things out. But you will save yourself a lot of trouble, a lot of headaches, and a lot of time if you have those calls, because you'll get the people, the lawyers especially, that you get off the phone with them and you're like, they literally hate the other side. Okay, we do not need to be doing an opening statement here.
You find, just right. Another quick question, do you find that different between online or virtual mediations and in-person mediations?
I do. I think that it's certainly less contentious on the virtual side. There is something special and unique about being in person together. An insult received through a computer screen, it lands a lot different than sitting across the table. I also find that most of the people doing the virtual ones, big cases, complex cases, people still love to really get in person. And I think that that's right. They can be very delicate. They require, there's just different considerations that go into them. Most of the virtual ones that I've been handling, the parties are pretty motivated to get in there, or they're just doing it to check a box off for a court. But I do find that there is a different emotional aspect and response because it's coming through a screen,
Right.
So it's different in that sense.
So one of the questions we've got is, if you don't start with each party with their stating their opening statements and giving their positions where they see things, how do you start? What are some good ways to get things moving?
Great question. I've tried out a couple different ways. The one that I found is most successful is I will have the conversations with the parties, whether it's just clear to me, and I should say this. I ask them, do you want to have an opening? And most of the time it's, we can, sure. Does the other side want one? So if both parties say, I don't really care, or I don't want to do it, it's very easy. The ones that are more difficult, you talk to the lawyers, you talk to the parties, whatever the case may be. If I get that sense that there's a lot of animosity, a lot of aggressiveness in it, I will just be taking my notes as we're having our conversation, and I'll say, you know what, we're not going to do an opening statement. What I'm going to do is my opening statement as the mediator to explain to the parties what we're about to do, how the process is going to go, ask if they have any questions, and then I will recap the matter as I understand it at that point and ask for any clarifications from the parties while we're together. So, for instance, mediation a little while back, the parties just hated each other. It was very clear that it would have turned into a screaming match as soon as I gave one of them an opportunity to talk together in the room. So I did my little opening spiel for everybody. And then I said, as I understand it, here are the facts that we are dealing with. And I went through it and I said, does anyone have any points of clarification? Did I miss anything that's vital at this moment? Everybody shook their head no. I said, great. Thank you all for being here in good faith. I'm going to bring you to your rooms now, and we're going to get this process started. And I do think that has been very effective, because you don't want to start going into the rooms when you don't have a true understanding about what the case is about. And if you're not letting the parties do an opening statement, then you need to make sure that all the parties are on the same page, that there's no misconceptions, that, in a personal injury case, plaintiff says, I got $100,000 in bills. The defense says, well, we only have 50. That's a big, big difference. And it will have a material impact on your ability to get the case settled. So being able to clarify that, but you as the mediator controlling the output of information, and you're just looking for, clarification, or this is right, this is wrong. And then you can have a conversation that you control, rather than giving the mic to the parties that are just going to go off and start bashing each other over the head. I hope that helps and hit what you're trying to get to. I'm going to skip over a few of these things because we do have some materials that I know that everyone has gotten a hold of with mediating with pro se versus represented parties. And I want to get to the business of mediation, because this is what personally was my biggest question when I was thinking about and then making the transition to becoming a neutral. And it's probably what I get asked most about from people looking to make that transition from advocate to neutral. I think mediation is awesome. I love it. As Erica mentioned in her very kind opening, I see myself as kind of an engineer. I like to build things. I like to build bridges. I like to build deals. I like to bring things together. So for me, it hits a lot of different positives. It's a great lifestyle. You get to control your time for the most part. You might not know when a mediation is going to end, but at least you can control, like, I'm going to work on these days and I'm not going to work on these other days. It's offered a lot of opportunities as far as career growth. You get so much exposure to different matters, subjects that you'd never considered, things that will end up interesting you. And I've had that experience. I've had some mediations where I've gone off and wanted to learn more about those topics, and I've gotten involved in those subjects because of it. And it is just a constant process of learning about people, how to interact with them, how to understand them, how to help shepherd them to a decision-making. Because a lot of these parties that come in, they just want to be told what to do. What do you think? And I think that that's one of the big pitfalls that we can fall into coming from an advocate to a neutral is, as the advocate, we oftentimes will tell clients what they should or should not do. And as a neutral, that is not your job. It is not your job to put the finger on the scale and make a decision or push a party to a decision. It's your job to walk them calmly up to a point where they believe they are making the best decision for themselves that day. And that's different for every single party that comes in. So you're always going to be learning about people, about subjects, about medical conditions, about investments in divorce cases. You're going to be learning about new contractual provisions that you've never heard of because you haven't looked at a contract with law school. It just offers a really unique way to kind of take your life back and control what you're involved in, how deeply you're involved with things, and expand your horizons as far as the people that you're going to come into contact with.
So Brian, do you still practice law while you're doing mediations?
I do. I do not do litigation anymore, but I do practice law. I keep a very low case count. And for the advocates looking to transition to becoming a neutral, that does become an issue. Especially when you're talking in, if you are, like I do personal injury representation for plaintiffs, those insurance companies don't want to give me the full story. They don't want to be fully honest with me. They don't want to share the inner workings and talk about how the sausage is made if they know that I can walk back out and use that information against them in my own cases. So I have been actively lowering my case count to hopefully just be full-time, taking no more cases by July of this year. So I do practice, which makes it a little bit challenging when you've got to switch the hats off, but you figure out how to do that and how to step into a neutral role as opposed to an advocate role.
So you're obviously hitting all the topics that our folks want to hear about. So I have two pending questions. We'll start with this first one.
Sure.
Marketing. So obviously, if you're being able to make that transition where you have more control of your life and you're not having to take litigation cases, you're getting lawyers to want you as a mediator. So what tips do you have for our audience on marketing?
Yeah, great question. I will tell you, so one of my good friends, he's an outstanding mediator. We now work together through Fourth Party. Gino Brogdon Jr., he's over at Miles Mediation. I asked him the same question, and I said, so what's the most important thing about getting mediations? He says, you have to remember that the parties will mediate with those people that they want to spend 4, 5, 6, 7, 8, 10, 12 hours with. You have to be that kind of person that is that can make connections with others, that can make the process that everyone's going through in a mediation an enjoyable one, even though you're there about a conflict. So what I tell people about networking is, I say, write down the last 20 lawyers that you had a good time working with. And I don't care if that was working on a case or you met them at an event and you had a good conversation. Write down those 20, reach out to them, and if you have gotten your mediator certificate, or if you're thinking about it, reach out to them and say, hey, I'm mediating now. I'd love to take you out to lunch, catch up with you, and talk to you about my mediation practice, and just let you know what I'm doing these days. So if you have a case that's that you think I'd be a good fit, you have all the information and we can mediate some cases together. Because the truth is, people, these lawyers, they want to mediate cases with folks that they like and they trust. And that only comes from knowing them. So I don't think that it's worth spending any money on advertising, any of that kind of stuff. It's all about utilizing the network, the connections that you have now. And then once you've done a few mediations, it starts turning over. Our legal community is, like, number wise, it looks big, but it's really small. And you do a great job for somebody, they're going to be talking to another lawyer week, 2 weeks, 2 months down the road, it says, hey, do you know a good mediator? This is what I got going on. Oh yeah. Go do it with Gino. I had a great experience with them, blah, blah, blah. On top of that, referrals, talking to other mediators, because the truth of the matter is you can't mediate all the cases out there. You just can't. I don't care who you are. There's only a certain number of hours in the day. So talking with more experienced mediators, they might be in a position where they get asked to mediate cases that just isn't worth their time. And I mean that quite literally, where they say, hey, I only do like big death cases and they're 2 and 3 day mediations. I just don't have time in my calendar to handle the $25,000, the $50,000, the $100,000 car wreck case. Get in touch with them, talk to them, ask them for tips, ask them for pointers on how they grew their practice, and then just be upfront with them and say, hey, if you ever get any inquiries about mediating matters that just aren't in your wheelhouse, you don't have time for, I'd love for you to keep me in mind. And, if my name pops into your head, let those parties know. I'd be happy to do some really great work for them. So I view this as especially one of those areas where it's all about personal relationships, all about it. And then after that, it becomes a combination of personal relationships and results and the experience that the parties had with you.
So, and a follow-up with that, because you mentioned you recently joined Miles, and Miles is getting larger and larger as the days go by and opening offices. Do you have any tips for our folks on if they want to get associated with the Miles? So there's Miles and Bay, there's AAA, Honey. Thoughts about folks reaching out to them?
Yeah, they. I won't speak for the management at any of these firms, but I think that the first question to ask yourself is, what kind of lifestyle do you want as it relates to your mediation practice? Okay, I know plenty of mediators that are just happy to do five mediations a month on their own, all virtually. Okay, and I spent 9 months doing mediations on my own, started my own little mediation firm. Had to cobble together a bunch of technology, which is one of the reasons why I came on with Gino and his lovely wife with Fourth Party, because I think it's a great platform. And that's something I'll shamelessly plug here. Is one of the biggest issues is getting your practice set up. Traditionally, it was very hard for mediators to do this on an independent basis, because you'd have to hire staff or spend a lot of time, with endless email chains to get the parties on the schedule and agree to a date, creating documents on your own, communicating with the parties. It was a lot. So you were left with 2 choices. Let me hire some people to help me, or I'll do it all on my own. So what's the last thing you want to do after an 8-hour mediation? Sit down and see an email chain of people going back and forth and trying to herd a bunch of cats to get on a calendar. Today, it's a little bit different. You've got firms like Miles and Bay, AAA, and all that will handle all of that stuff for you, the scheduling, getting documents to everybody. But it does cost you. They're not doing it for free. That's part of your agreement with them, that they will that you will, in one way, shape, or form, pay for the services that they're helping you with. Or you can utilize a technology stack or a standalone solution. I cobbled together a Calendly and Panda Docs to generate documents, invoicing through QuickBooks, payments through Stripes, all these things I cobbled together using Zapier and other tools. That was not the easiest thing in the world, and it kind of broke, but it allowed me to actually mediate cases and not spend a whole lot of time on the administrative. Or you can use something like Fourth Party, which has it all there for you. So as far as going to the firms, to the bigger groups and everything, a lot of them, it's more of an invite situation, although I would not discourage anyone from reaching out. But before any of that happens, I would encourage you to get real clear on what do you want out of this? Some people want to mediate 20 days a month. they want Monday through Friday a mediation every day. Some people, they just want to dabble in it here and there as an extra little side income stream. I know a lot of lawyers and judges that look at it as more of a easing into a retirement kind of setting. So maybe they don't want to go full time, but they don't want to just do two. So I would encourage you to get clear on what do you really want out of it, you know? And once you get that answer, you're going to have a clarity that allows you to realize, like, maybe the firm, the group thing is not for me. I'll just do it on my own, and I'll use a technology like Fourth Party or and there's some other ones. Don't think that they're as good, but that's my bias coming through there.
Yeah, Fourth Party is a Georgia-based company, so we'll go with that. And Gino's a member of this section, so we'll go with that. But so we have I have two pending questions here, and the first about payment. How do you avoid having to chase down the lawyers to get payment, whether the mediation is successful or not?
Oh, okay. Well, this kind of dovetails nicely with the previous question. If you're with a firm, they're going to handle most of that for you. For those that are not mediators or don't have experience with them, they're usually on a net 90. So you do the mediation today, payment is due within 90 days. They encourage them, they start reaching out earlier. But again, you're going to pay for that service with whoever you're with for them to do it. And that might be worth it for you. I found that when I was mediating on my own, setting up automated email reminders, I cobbled together through Stripe, it would send out an invoice and you can set reminders on there for the system to tell you, like, hey man, you haven't been paid for that work that you did 3 weeks ago, might want to reach out. One of the things that we've built into Fourth Party is it automatically does it for you. You finish up your mediation, you click, we settled it, you enter in a few details so that you can keep track of all of the pertinent facts. And then the system sends out the invoice. The system reminds those parties, hey, you need to pay this, you need to pay this, you need to pay this. And then eventually it tells the mediator, like, hey, we're having problems here, like, just make the phone call. I have not yet encountered anybody that I haven't found any nefarious people out there that just didn't want to pay me for the work that I've done. Most people just get too busy, too overwhelmed. They just need reminders. And the best way to do that I found is let a system do the reminding for you. I don't want to be that person that hops on the phone every week and says, hey, still haven't paid me. I just don't, I don't think that helps foster relationships, but it is finding that nice balance of utilizing something that can remind them gently for a while, and it keeps your personal relationship in a very positive place. And then once you get to a certain time frame, 60, 90 days, then you can call and say, hey, I need you to pay me. And ultimately, as the mediator, you can always go to some higher ups to make that kind of stuff happen. The courts will ask you, have you been paid for your work? If you tell the court that you haven't been paid, they're going to make sure that happens. And that doesn't come up very much. I actually have never had it happen to myself, but I have talked to mediators that's been an issue, and that's been a way that they've solved it. But the other part that I'll add to that is one of the easiest ways to make sure you get paid is developing those really great relationships with people and doing a great job for them. And that doesn't mean that you settle every case. It just means that you give every case that you mediate the attention, the personal touch that it deserves. And if you do that, that's a successful mediation in terms of your relationships. And if you have good relationships with these lawyers and law firms and insurance companies, they're going to pay. But I would encourage you, if you're going to do this as a solo, just your own mediation practice, you can do what I did, try and figure it all out, cobble it together. It works. I would encourage you, just skip that, go with something like Fourth Party. It does it all for you. Makes your life a lot easier. I wish I had a Fourth Party back when I started, is I guess how I would put it.
So I know you probably can't share all of the details, but for those people who are interested in not doing it on their own and paying for paying to be with a Miles or a Bay of that type, what is the standard financial relationship? So like, for example, we all know for JAMS, when you're doing it, that they say off the top, we charge a 3% on top fee for everything you do at JAMS. We don't see that when we're at when you're hiring Miles, you don't see that they're tacking on the fee. Are they taking it out of your hourly rate? Or is it a flat fee that you have to pay? What's the?
Yeah, the standard out there, and virtually all of these come with non-disclosures, but I'll talk in a general sense. The more full service the firm is, it's going to be a percentage of your billed charges. So it's not necessarily like, oh, I'm going to pay you $200 for this mediation that I'm going to conduct today and at your property. It's more of, hey, it was a 5-hour mediation, $1,000 an hour, $5,000. You get a certain percentage for letting me use the space, providing administrative support, doing the invoicing and billing, doing the following up, taking in payments, processing all that. So they are generally structured more as a percentage of the billed charges for the mediation.
Okay, so that's consistent with JAMS. JAMS just tells you that it's the arbitrator's, $500 an hour. We're taking our 3 to 5% on top of that. So they tell the parties, right? So we don't know with the other ones. So that's very interesting. And we do not want you to violate any non-disclosure agreements, but it is right. I mean, for somebody who's looking to make that transition to a mediator, I want to know how are we going to get paid? How are we going to get paid?
Well, it is, and it's a big deal, and that's why I really, and I'll emphasize it again, understanding what you want as a neutral, what do you want out of this is just incredibly important, because that does eat into your take home. If you want to do 10 cases a month, but you're paying a certain percentage to a firm, then your true take home is very, very different than if you did 10 cases on your own. So understanding what is it that I want out of it, and if you're one of those people that just wants to go it on your own, I support you 100%. I think that's awesome. And again, I encourage you to let computers, let programs, let other people do that kind of work for you, because the most important things that you can do are twofold. One, mediate cases. You're the only one that can do it. Just get out there and mediate cases. But in order to do that, you need to be doing outreach, going to meet with people, going to events, going to, the Defense Lawyers Association events, going to the Georgia Trial Lawyers Association events, going to, hey, I go to churches. I've got a relationship with the HR at a, Fortune 100 company, and I help mediate disputes with their employees. Getting out there, connecting with people, making those relationships, developing them, nurturing them. Those are the two most important things you can do. Not the invoicing, not the billing, not any of that stuff. That's all necessary. But if you don't have cases coming in to mediate, if you don't have people that want to use you, it doesn't matter. So I would encourage everyone to look for those technology solutions that can do all of the necessary things for you, the administrative side, so that you can just focus on those two important things, create, develop, maintain relationships, and then just mediate cases, because those are the ways that you're going to grow your practice.
All right, we probably have time for one more question if somebody wants to type something in. I'm not seeing anything. Nothing typing up yet. Well, Brian, this has been fantastic. Thank you so much for joining us and sharing with us how you've made that transition. You had some great tips and insight. Really, really appreciate your time, and particularly putting the materials together for everybody for their CLE, which is still pending, but everybody will get that hopefully here soon. And if you have any further questions, Brian had his contact information up there, feel free to email me at ericaberg@nelsonmullins.com, and I will pass it along to Brian. But thank you all so much. I believe we will be having a meeting sometime in June to elect our officers for the State Bar section, and hopefully some bylaws. We're working on all of that, and we will see you then. Thank you. Y'all have a great day.
Thanks, Erica. Thanks, everybody, for coming.
Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.